Picture this. You are walking down the street on an ordinary Tuesday afternoon. Maybe you are heading back to your car after picking up groceries. Maybe you are walking to your office after lunch. Maybe you're just getting some air after a long day. You are a law-abiding citizen. You have done everything right. You went through the background check. You completed the training. You obtained your license. You are carrying legally, responsibly, exactly the way the law intended. And then a police car pulls up beside you. The officer steps out and he tells you to stop. You are being detained, not because you did anything wrong, not because you matched the description of a suspect, not because anyone called 911 about you specifically, but because the officer saw the outline of your firearm through your jacket, or noticed the clip on your belt, or simply observed something that looked like it might be a gun. And for decades in this country, that was enough. That single observation, the sight of a firearm on a law-abiding citizen who had done absolutely nothing wrong, was legally sufficient to justify stopping you, detaining you, frisking you, and potentially turning your entire day into a nightmare. But something has changed. Something fundamental and far-reaching has shifted in the legal landscape of this country. And if you carry a firearm legally, you need to understand exactly what changed, why it changed, and what it means for you the next time you walk out your front door. Stay with me because this is one of the most important legal developments for gun owners in recent memory, and I am going to walk you through every piece of it. To understand the full weight of what just happened, you have to go back to 1968. You have to go back to a Supreme Court case called Terry versus Ohio, because that case is the foundation of everything we are talking about today, and you cannot understand the new ruling without understanding what Terry established and why it has been so deeply controversial for more than half a century. In Terry, the Supreme Court created what legal scholars call a significant exception to the Fourth Amendment's general requirement that a search or seizure must be based on probable cause. The court reasoned that a police officer should be allowed to briefly stop and frisk a person if they have what the court called reasonable suspicion that criminal activity is afoot and that the person may be armed and dangerous. The standard was deliberately designed to be a low bar, considerably lower than proof of wrongdoing by a preponderance of the evidence. It was meant to give officers a flexible, practical tool to investigate potentially dangerous situations quickly and without the delay that obtaining a warrant would require. And for over 50 years, that standard became a cornerstone of criminal procedure across the entire country. But here's the problem with reasonable suspicion, and it is a problem that legal scholars, civil rights advocates, and constitutional attorneys have been wrestling with for decades. The standard is deeply, inherently subjective. What exactly counts as reasonable suspicion? What specific observation is enough? The courts over the years allowed police to point to an enormous array of factors that would be completely innocuous in any other context. Being in a high crime area, making furtive movements, looking nervous, acting fidgety. These are the kinds of observations that transform Terry stops from a narrow investigative tool into something much broader and much more susceptible to abuse. The dissenting opinion in Terry itself warned about exactly this danger, stating that to give the police greater power than a magistrate is to take a long step down the totalitarian path. That warning turned out to be prophetic because in practice, the vague and subjective nature of reasonable suspicion turned the Terry stop into something that fell with disproportionate force on minority communities, on people who were doing nothing wrong, and on law-abiding citizens whose only offense was existing in a space where an officer decided they looked suspicious. This is the environment into which the new ruling has just landed, and this is why the ruling matters so profoundly. For decades, in many states across the country, the mere possession of a firearm, especially a concealed one, was treated as inherently suspicious. In places like New York, which had one of the most restrictive licensing schemes in the nation, an applicant had to demonstrate what the courts called proper cause, which was interpreted to mean a special need for self-protection that was distinguishable from the general population. This effectively transformed public carry from a constitutional right into a privilege reserved for the well-connected or the wealthy. If you lived in New York and an officer stopped you and found a gun, the assumption built into the legal system was that you were probably breaking the law. The burden was on you to prove otherwise. And that assumption, that deeply embedded presumption of guilt attached to the simple act of carrying a firearm, is what the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen fundamentally destroyed. Bruen was a seismic event in Second Amendment law, and if you have not fully absorbed what it did, you need to understand it now, because everything that follows flows directly from it. The court struck down New York's proper cause requirement, holding that it violated the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. The court made a declaration that was as clear and as sweeping as anything the Supreme Court has said about the Second Amendment since Heller. The Second Amendment protects the right to carry a handgun outside the home for self-defense. Full stop. No qualifications, no carve-outs for ordinary citizens going about their ordinary lives. And then the court did something else that was equally important. It established a new standard for evaluating gun laws going forward. Under Bruen, any gun regulation must be consistent with the nation's historical tradition of firearm regulation. If the text of the Second Amendment covers an individual's conduct, and the court made explicitly clear that it covers public carry, then the government must justify its regulation by demonstrating that it aligns with America's historical traditions dating back to the founding era. This was a direct and decisive rejection of the two-step approach that many lower courts had been using, an approach that often involved a balancing test that effectively allowed states to weigh their interests against the individual's constitutional right. Bruen told the lower courts that if the right is in the text, it is presumptively protected, and the government bears the burden of justifying any restriction through historical analogy. Now fast forward to the aftermath of Bruen, because the aftermath is where the practical consequences for you as a gun owner become absolutely concrete. Bruen fundamentally changed the legal landscape in every state where the law had previously presumed that carrying a gun was a crime unless you could prove otherwise. That presumption was turned on its head, and once that presumption was gone, a critical legal question immediately emerged. If the Second Amendment guarantees the right to carry a gun in public, and if the law now says that carrying a gun is a presumptively lawful activity, how can the mere act of carrying a gun still give police the reasonable suspicion they need to stop a citizen? That is exactly the question that courts across the country have been grappling with since Bruen came down. And the answer that has now emerged from those courts is the answer that changes everything for you. The Fifth Circuit Court of Appeals addressed this question directly in United States versus Wilson in 2025, and what it held is something that every legal carrier in this country needs to know by heart. The Fifth Circuit held that a police officer's suspicion that an individual is carrying a concealed firearm because it is a presumptively lawful activity cannot be the sole basis for an investigative stop. Read that again slowly because it is important. The court is saying that a police officer cannot simply point to the presence of a firearm as the reason for detaining you. They need something more. They need a specific, articulable reason to believe that a crime is actually being committed, not just that a firearm is present. The court went further and made a point that connects the Second Amendment issue directly to the long-standing civil rights concerns about Terry stops. It argued that treating gun possession as inherently suspicious what it called establishing firearm exceptionalism in the reasonable suspicion calculus would only further entrench the already problematic deference to racialized policing that has made Terry stops so controversial for so long. This is not a small point. The court is explicitly connecting the constitutional right to carry with the equal protection concerns that have surrounded stop and frisk policing for decades, and it is doing so in a way that raises the bar for both. The Wilson decision did not stand alone. A major state appellate court in Maryland reached the same conclusion in the case of Stephen Hicks, a licensed gun owner who was stopped by a Baltimore police detective who claimed he could see Hicks's gun printing through his shirt. The court found that stop to be unconstitutional. Judge Catherine Graff wrote for the court that officers stopped the appellant based solely on his possession of a gun without reasonable suspicion that he was possessing the gun illegally or otherwise involved in criminal activity, and that the stop therefore violated his Fourth Amendment right against unreasonable seizures. The Citizens Committee for the Right to Keep and Bear Arms summarized the ruling's significance precisely when they said that the Hicks ruling is a wake-up call to Maryland police. They can no longer treat a constitutional right like a regulated privilege. That sentence captures exactly what this shift is about. The presence of a gun in a jurisdiction where carrying that gun is a lawful activity is no longer evidence of a crime. It cannot be used as the basis for treating you like a suspect. It cannot be used as the pretext for stopping you, detaining you, and searching you. The constitutional right is the constitutional right, and exercising it does not transform you into a criminal suspect. Now, before you walk out that door thinking the police have no authority over any interaction involving a firearm, let me be very clear about what this ruling does not do, because understanding the limits of the ruling is just as important as understanding the ruling itself. This ruling does not make you immune from police contact. It does not create a force field around you because you are carrying legally. What it does is raise the bar for what justifies a stop. An officer can still detain you if they receive a credible, specific, reliable tip that you are carrying illegally. They can still stop you if they observe behavior that is independently suspicious apart from the firearm, behavior that suggests you are about to commit a crime or have just committed one. They can still investigate you if gunfire has just been reported in your immediate area and you match a description. The difference is that the gun itself, standing alone without anything else, is no longer enough. The articulable suspicion has to come from somewhere other than the simple fact that you are exercising a constitutional right. The federal district court case of United States versus Davis in Michigan illustrates exactly where this line sits in practice. Officers spotted an L-shaped imprint in Davis's pocket from about 58 feet away. Based on their training, they believed it was a firearm. They approached and asked if he had a valid concealed pistol license. He remained silent. Then they observed a firearm magazine visibly protruding from his pocket. The court upheld the stop, but here is the critical detail. The court did not uphold it solely on the basis of the gun. It upheld it because the combination of the visible imprint, the man's failure to acknowledge a license in a state where carrying without one was a felony, and the visible magazine together created sufficient reasonable suspicion. Each element contributed to the whole. The gun alone was not enough. Context, behavior, and the specific legal landscape of the state all mattered. This brings us to the practical steps you need to take right now before you walk out of this room to protect yourself under this new legal framework. The first and most fundamental thing is to know your rights thoroughly and specifically for your state. The legal landscape varies significantly from state to state. Constitutional carry states where you do not need a permit to carry, operate under a very different framework than states with more restrictive licensing schemes. Know exactly what your state requires, what your obligations are during a police encounter, and what your rights are if you are stopped. The second thing you need to understand is the right to remain silent and how it interacts with firearm encounters. In the Davis case, silence contributed to reasonable suspicion because of the specific legal context of that state. In a constitutional carry state or a state where your license is clearly in order, the calculus may be entirely different. This is not a one-size-fits-all answer, and that is precisely why you need to know your specific state's law before you find yourself in a situation where you have to apply it in real time. Third, understand that this ruling has implications that extend far beyond pedestrian stops. Consider what it means for traffic stops. If an officer pulls you over for a broken tail light and sees a firearm on your seat under this new framework, the firearm alone cannot be used to expand that traffic stop into a broader criminal investigation. The officer has authority to investigate the traffic violation that caused the stop, but the presence of a lawfully carried firearm does not give them independent justification to treat you as a criminal suspect, demand to search your vehicle, or hold you longer than the traffic stop itself would otherwise require. This is a meaningful, practical protection for gun owners who carry in their vehicles, and it flows directly from the same constitutional logic that underlies the pedestrian stop ruling. Fourth, be aware of the exclusionary rule and why it matters in this context. The Supreme Court has long held that evidence gathered from unconstitutional stops must be suppressed and cannot be used against you in court. This means that if an officer stops you solely because you are carrying a gun, and during that stop finds something else, drugs, an unrelated weapon, any other contraband, that evidence may be thrown out entirely because the stop that led to its discovery was itself unconstitutional. This creates a powerful incentive for law enforcement agencies to update their training, revise their policies, and ensure their officers understand the new legal landscape. Departments that do not adapt are going to find their cases falling apart in court. Fifth, understand the sensitive places exception because it is real and it matters. The Bruin decision explicitly acknowledged that states retain the authority to prohibit firearms in sensitive places: schools, government buildings, courthouses. The court pointed to these categories as examples of historically grounded restrictions that can survive constitutional scrutiny. But the court also rejected the argument that the sensitive places category could be stretched so broadly that it effectively swallowed the right entirely. On the street, in a grocery store, in a park, in a restaurant, in the ordinary public spaces of everyday life, the rules have changed, and they have changed in your favor. The legal significance of what has just happened cannot be overstated. For the first time in modern American legal history, the intersection of the Second Amendment and the Fourth Amendment is being resolved in a way that treats the right to carry as a genuine constitutional right rather than a heavily regulated privilege. The Bruin standard, requiring that gun regulations be grounded in the historical tradition of the founding era, is now doing exactly what its authors intended. It is forcing courts and law enforcement agencies to confront the reality that the Constitution means what it says. The right to keep and bear arms is a right. Exercising a right does not make you a suspect, and a government that treats the exercise of a constitutional right as inherently suspicious is a government that has lost sight of what constitutional rights are for. Before we close, the standard legal disclaimer that matters here. Everything I have shared with you today is for educational and informational purposes only. This is not legal advice. Laws vary significantly by state and by jurisdiction. This area of law is actively evolving and subject to change as new cases work their way through the courts. Nothing in this video substitutes for consultation with a qualified attorney licensed in your specific state who can advise you on your specific situation. If you carry a firearm regularly, having a relationship with an attorney who understands Second Amendment and Fourth Amendment law in your jurisdiction is not a luxury. It is a practical necessity. Know your rights before you walk out that door. Share this video with every legal carrier you know. because this ruling changes the rules of engagement between law-abiding gun owners and law enforcement in ways that every single one of them needs to understand. Subscribe right now so you do not miss the follow-up coverage as this legal battle continues to develop in courts across the country, because it is going to keep developing, and when it does, you are going to want to know about it the moment it happens.